Breaking. The SEC has filed a letter of intent to request an interlocutory appeal to Judge Torres' July 13th summary judgment in the SEC versus Ripple case. Interlocutory review is warranted here. These two issues involve controlling questions of law on which there is substantial ground for differences of opinion as reflected by an intra-district split that has already developed. Judge Torres says the court will seek to schedule a jury trial for the SEC versus Ripple case in the second calendar quarter of 2024. Torres has ordered both parties to submit blackout dates for trial by Wednesday, August 23rd. On July 13, 2023, the court granted in part and denied in part the parties' motions for summary judgment. The court will seek to schedule a jury trial for the second calendar quarter of 2024 accordingly. Firstly, by August 23, 2023, the parties shall submit blackout dates for trial by December. For 2023, the parties shall submit any motions in limine. Oppositions to any motions in limine shall be submitted by December 18, 2023. Third, by December 4, 2023, the parties shall submit all required pretrial filings, including their proposed joint pretrial order requests, to charge verdict form and vor. Dire questions in accordance with paragraphs VB, VC, and VD of the Court's individual practices in civil cases. The parties shall also email copies of these submissions to Torres Chambers. Fourth, by December 4, 2023, the parties shall deliver to the court one copy of each documentary exhibit sought to be admitted, pre-marked, labeled with exhibit stickers and assembled sequentially in a loose leaf binder or in separate manila folders labeled with the exhibit numbers and placed in a suitable container for ready reference in accordance with the court's individual practices in civil cases. Lastly, the court shall schedule a final pretrial conference date upon setting a date certain for trial. Eleanor Terrett in tweet said, "From everything I've learned about interlocutory appeals from the brilliant legal minds in this space, they are notoriously tricky to get approved. The SEC will need to get blessings from both Judge Torres and the Second Circuit in order for this to be granted," she added again. Extra clarification. This trial will decide some disputed facts that Judge Torres did not rule on in summary judgment. The jury will only be debating whether or not Brad and Chris aided and abetted in selling unregistered securities. Torres' summary judgment decision still stands and has not been appealed by the SAICC at this time. Judge Annalisa Torres of the U.S. District Court for the Southern District of New York ruled last month that the cryptocurrency company's sales of XRP to sophisticated investors met the requirements for an investment contract under federal securities law. She reasoned that the purchasers would have understood that Ripple was pitching a speculative value proposition for XRP with potential profits. This ruling came 1 month after the U.S. District Court for the Southern District of New York issued its ruling. The judge, however, ruled that this did not apply to programmatic investors, which means members of the general public who acquire cryptocurrency on exchanges. Since its inception, the topic of whether or not cryptocurrencies qualify as securities has been one of the most pressing concerns for the industry, which maintains that it is exempt from the authority of the Securities and Exchange Commission and other regulatory bodies. According to the SEC, the Ripple case is only one of dozens that have resulted in varying decisions from the judges who were asked to rule on the issue. On Wednesday, the agency informed Torres that it intends to seek permission to immediately appeal her order to the Second U.S. Circuit Court of Appeals. The agency stated that a timely review is required because of the number of actions currently pending that may be affected by the way in which the appellate court rules the case. A decision from the court could put an end to any outstanding legal problems and lend some degree of coherence to decisions made by subordinate courts. In the wake of the SEX action, attorneys for Ripple Labs did not immediately respond to emails requesting comment on the matter. According to the SEC, the finding in favor of Ripple with relation to retail sales encompasses controlling questions of law because they disposed of the SEC's claims regarding defendants' offers and sales at issue, which led to the dismissal of claims covering more than half of RP's offers and sales. According to the complaint, the debate brings up critical enforcement problems for the agency in a number of cases that are now pending, including one that was just taken against Coinbase. The SEC has filed a lawsuit against Coinbase, alleging that the company is illegally running an unregistered securities exchange, broker, and clearing agency. Coinbase submitted a motion to dismiss the matter to a judge last week, citing a decision made by Ripple. The Securities and Exchange Commission has stated that an appeal may have an effect on the pending litigation in which it accuses the cryptocurrency exchange Binance Holdings and its chief executive officer, Changpeng Zhao, of breaking securities laws, mishandling customer cash, and misleading investors as well as regulators. Because the judge's decision did not put a stop to the Ripple case, the SEC needs to get permission from Torres before asking the appeals court for an expedited review. It will be up to the government agency to convince the court that the decision at issue raises a controlling question of law, that there is substantial ground for difference of opinion, and that an urgent appeal may help move the case along more quickly. The Securities and Exchange Commission made notice of the fact that a judge in the same courthouse had categorically dismissed Torres' strategy in the action brought by the regulator against Terraform Labs, and its co-founder Do Kwon. U.S. District Judge Jed Rakoff determined that the company's Terra USD token may in fact be a security when sold to retail investors. This decision was made in the context of the case, even while the SEC stated that it would be quick to resolve the legal issues now rather than waiting until after a final decision in the trial court. A future trial in the Ripple case might be delayed by months if an appeal is filed. From Bruce Fenton, today I went to SEC headquarters in Washington, D.C. to call for the resignation of Chairman Gary Gensler. Securities are the lifeblood of the economy. Securities is my industry and has been for my whole life. It is deeply important to me, and it is crucial to the American people and the world to rid the space of bad actors. Chair Gensler is a bad actor. Chair Gensler's oversight and ties with fraudster SBF, his placing of woke partisan ESG politics and personal cabinet ambitions above the Constitution, his capricious and ham-handed handling of the digital assets space, and his lack of transparency harm the industry and harm the American economy. I want bad actors out of my industry.
I'm here in Washington, D.C. at the U.S. Securities Exchange Commission to call for the resignation of Chairman Gary Gensler. This is my industry. I've been in this industry my entire life. I grew up on the floor of a brokerage firm. I got my first job at 14 at a major Wall Street firm. I got licensed at age 19 and I've been licensed ever since for over 30 years with a flawless compliance record, working with broker-dealers and registered with the SEC. It is absolutely crucial that the United States markets maintain its place as a respected global market, free from fraud and bad actors. Mr. Gensler, your chairmanship and your behavior does not jive with those goals and does not help the United States markets. I'm calling on you to resign for many reasons. The ties with Sam Bankman-Fried and your agency overseeing the largest fraud since Bernie Madoff is reason alone for you to resign. Frankly, I was surprised that you lasted a couple weeks after this. You had extensive ties with the largest fraudster that we've seen in a generation. You gave him unprecedented access, the kind of meetings that no one else in our industry is able to get. You have ties with him, with his president, and his general counsel who used to work with you.